Welcome to the Cinnaire MSHDA 2020 Virtual Asset Management Conference. Thank you for your interest in our virtual sessions. We hope you enjoy Eviction during a pandemic.
Hi everyone, welcome to the Cinnaire MSHDA virtual conference session on evictions. My name is Joe Tandy with my counterpart David Soule, Regional Vice President for KMG Prestige, your host company for today's session. I think we can all agree it's been a very interesting and challenging year. As if property management isn't challenging enough, this year the coronavirus pandemic completely changed how we operate to ensure we protect our residents, all while trying to maintain cash flow and order within our communities. As we began dealing with the pandemic, we quickly saw a shelter in place that required businesses to close to only essential employees, creating a loss of income and uncertainty for many of our residents and clients. This led most of us to questions like, from a resident standpoint, how will I pay my rent? Will I get evicted? How long will they work with me, if they will even work with me, to stay current and not evict me? Our community managers are wondering, first of all, how they're going to collect the rent, thinking if they don't, their regional managers are going to be all over them because they're not following protocol. Do we do payment arrangements? Do we take partial payments when you typically don't? We could continue down this path, but this session is on the eviction side. So we're going to jump right to that. There's another session for you to watch relative to rent collections. We then had the eviction moratorium, the Federal CARES Act, the State of Michigan moratorium, the Michigan Supreme Court and local court interpretations of all of those orders only created more questions in how we comply with everything. What do we do about residents who are a hazard and a threat to our community, and how do we handle it appropriately? And frankly, as time went on, it only created more questions. So how do we deal with all of this? Great question. I'm glad you asked. To answer that, we have a panel of distinguished attorneys to walk us through it. So let me introduce them to you. First, we have Steve Gann of Gann Law Firm. Steve began as a paralegal in 1997, where he handled all aspects of landlord-tenant law, then passed the bar, became an attorney in 2014, and he opened his own practice exclusively representing landlords throughout the state of Michigan for landlord-tenant law. And he also focuses on teaching and addresses anything fair housing related. He's married with 2 adult children in college, one at Ferris and one at MSU. He says he's a rabid Spartan fan, and for those of you who know him, we all know that's true. So next we have Brian Bouchard of Gromer and Bouchard PLC. Brian has spent 17 years as an attorney and spent his entire career practicing landlord-tenant law. He began his career working with the United Community Housing Coalition in Detroit, working with low-income residents facing eviction. In 2008, he went to work for a Detroit attorney representing mom-and-pop landlords and small management companies. Together, they filed approximately 400 to 500 cases per month in Detroit. In 2016, he moved to MHT Housing and Continental Management as corporate counsel. His practice still focuses primarily on landlord-tenant law, with the bulk being within the city of Detroit, but also services properties across the Lower Peninsula. Last but certainly not least, we have Matthew Miller, with Swiss Stack and Levine, PC. Matt's statewide focus is on representation of landlords of multifamily rental properties in all forms of civil and commercial litigation, including real estate, landlord-tenant, consumer protection, and mold and contracts. Matt is also the legislative chair for the Property Management Association of Michigan and has been since 2007. A side note, he'll likely share a recent legislative win he obtained that will help all of us in the property management world. Matt has drafted multiple bills that governors have executed into law, while currently having others still pending in the legislature. He has written multiple amicus briefs for local apartment associations, and is the proud recipient of the PMAM President's Award in 2007, 15, and 17. He serves as a life board member and a past board chair for the Michigan Regional Office of the Anti-Defamation League, an international civil rights organization, and was selected to the Michigan Super Lawyers list for real estate in 2018 through 2020, along with being named DB Business Magazine's top lawyer in 2019 and 20. Matt is a U of M graduate and has been admitted to the state bars of Michigan, Florida, and Colorado, as well as the U.S. District Court for Eastern and Western Districts of Michigan and the U.S. Supreme Court. He's married and a father of identical twin 17-year-old boys. You know, attorneys like to spar, and they actually spar for a living. So this ought to be interesting because we've got both MSU and U of M here on our panel. So without further ado, I turn it over to our distinguished panel. Go Blue. Steve?
Thank you, Joe, and I'll take the lead. I'll take the start on this. Thank you for inviting me to be a presenter with this panel and at this conference. So we're going to take a little dip into the past, and we're going to talk about evictions. I will be talking about what evictions used to look like. Obviously, I know most of you have been in the business, and all of you have been in the business, and you already know. But we're going to do a little refresher because I think it's important to draw the distinction about between how easy things sort of used to be and how difficult they've become, which Steve will get into when I'm finished with my presentation. I think Steve and Matt decided to give me the happy part of this presentation because I think when we had our meeting about this earlier this week, I had just come off a very difficult day at 36th District Court, and I was very jaded. So they gave me the ability and the privilege of talking about happier times. So we're going to dial way back into the Wayback Machine and go all the way back to year 1 BC, which is before COVID. And that's, of course, 2019, before all of the changes began to take place. All of our kids were in school. We weren't washing our hands 40 times a day. Everybody had to wear pants to all of their meetings. And so things were just easier. So I'm going to go through the court filing process, from beginning to end. This will be very, very brief. Because again, I know all of you are familiar with that process. But in terms of the filing, we used to be able to call up relative or various courts to find out when they were scheduling their cases, so that we could kind of do some docket management, some scheduling management. That has by and large become very, very difficult because the courts, the way that the courts are required to schedule now has made it very difficult to schedule all cases at one particular time. So essentially we are guessing when we're filing cases as to when that court date might be. And so filing used to be easier. We just take our bulk cases, we'd send them to court, we'd get that court date, and that was that. We would file them in a batch, and we would have that same batch in court on the appointed court date. Service was and is the same still. Technically, the court rule hasn't changed with regard to service, but Steve will get into a little bit about how the court process around a served tenant is. That is the difference between somebody who was personally served as opposed to someone who was just served by attachment. But again, we would mail out the tenant's copy of the court proceeding, the court pleadings. We would send a process server out. They would knock on the door a couple of times and ultimately be able to tape the paper to the door. Voila, the tenant is served. Court process itself was I think for those of us who do it on a regular basis, which all three of us do, was very easy. You go to court on that batch of cases, whether it's 5 cases or 40 cases, you go to court, you show up, all 5 or 40 of your cases were scheduled at one time, 9 o'clock in the morning, 1:30 in the afternoon, whatever it may be. And we would go to court, and we would resolve almost all 40 of those cases. So if we went to court with 40 cases, we would come back with a handful of prearranged dismissals, a number of consent judgments, default judgments, and we might have 2 or 3 adjourned cases out of that batch of 40. So it was a very efficient process. We could unload the bulk of these cases in that one court hearing. That has changed fairly dramatically based on my experience, primarily in Detroit, and mostly the other places that I've been as well. But it used to be a very easy, very efficient system. And then the post-judgment process was easy as well. We would simply file our orders of eviction with the court. Sometimes, if obviously if that was delayed, we might be scheduled for a court hearing. The tenant didn't show up, our writs were signed, and we proceeded on to the eviction process. Tenant did show up, then we would have a quick conversation, and we would either modify an arrangement, we might give them some extra time in order to be able to gather their affairs and move out of the property. In some cases, we might work out a new consent judgment, but it was an easy process. We'd show up, the tenant would show up, we'd have the conversation, and we were done. Once COVID hit, after the shutdown and reopening of the courts, all of that has changed. I promised you that I would be very brief, and that is essentially our quick recap of what court used to be like. And so now I'll give it over to Steve, who's going to talk about what things are like right now.
Thanks, Brian. Okay, everybody, you've heard from the ghost of COVID past. I'm going to be the ghost of COVID present. Unfortunately, mine is probably going to be the scarier of the three presentations. Hopefully, Matt Miller will have some brighter outlook. But right now, the first COVID case happened in January 2020, and by March 27th, the CARES Act was put into place. The CARES Act put a moratorium on evictions from March 27th to July 25th, and it also came with a 30-day requirement for a notice if you want to kick somebody out after July 25th. You had to give them a 30-day notice and not just a 7-day non-payment. So in essence, this CARES Act ran from March through the end of August, or relatively through the end of August. It would have been easy for us attorneys if we just had to worry about one federal law that we had to deal with and we could get through it. But that's not the case. The governor has executive powers, and she has been not shy about utilizing them. And it seems like virtually every day or so, in fact, I think the average was about 1.2 orders per day, she'd issue a new executive order, and many of them did apply to landlords, and several applied to the eviction process. The first moratorium went in place, I believe it was mid-March, and then April 17th was the start of Michigan's first executive order number 2020-19, and that was the start of the complete halt in Michigan. The CARES Act applied to only federally covered properties. The Michigan order covered all Michigan residents and landlords. And basically, under that order, a landlord cannot even give a resident a demand for possession. The only time you could evict them, at the beginning, it was interpreted that if there was a health hazard or damage to property. Thereafter, it was changed and is interpreted more broadly to allow for evictions that were, at least you can issue the notices that for cases where they were just violating the lease. The CARES Act was initially going to be for everything, and then it was interpreted by HUD in mid-April to apply to only non-payments, allowing landlords to go after residents who were violating the lease on other grounds. And as far as my practice is concerned, there seems to be an uptick in the lease violations and so for lack of a better term, the craziness of some of the residents. The cabin fever that this COVID crisis has created has really made the eviction process very interesting, made the residents very tenacious, and it created a headache for everyone. So basically, the governor's order ended on July 16th. Thereafter, Michigan courts, you would think, would be free to open and just start filing and start moving again. Unfortunately, the Michigan Supreme Court came out and they put together their own Supreme Court order number 2020-17. That order actually created a priority of filing cases. I assume Brian and Matt would agree with me when I say that the order does not make a lot of sense. The first priority cases were the health hazards, which that does make sense. The second priority were residents who owed 120 days of rent or more at the time of filing. Then it went down to 90, 60, and 30 for the next three priorities. The last priority is the termination of tenancies. That falls in the same line with someone who owes just a month's worth of rent. In my opinion, the termination should have been much higher up on the list because they're the ones that are creating the headaches for the landlords. They're the ones creating the headaches for their next door neighbors with their loud parties. In some cases, they're COVID parties. It's amazing what some of these residents were doing. Now, going to the next thing that's happened to us is the CDC order. On September 4th, the CDC issued their order that says if a resident files a certification that they certify 6 different qualifying factors, we're not allowed to do an eviction on them through the end of the year. And this one is going to be, this is a nationwide. Now, the 6 factors, most of them are pretty generic, but 2 that come into play for us are, in Michigan at least, did they have a reduction in their income, a substantial reduction in their income? And number 2, have they applied for all available government funds? Those are the 2 areas which I tend to notice that residents tend to lie on the form, and we've been able to bring that to the court's attention. Courts are allowing, at least most of the courts in Michigan are allowing us to question the residents on that in court. And often that will allow us to resolve a case when the resident realizes that they actually lied under penalty of perjury on this form. Now, I'd be forgetting a lot if I didn't decide to mention the 36th District Court. And I know if you look up at the screen there, you're going to see Brian starting to twitch right here because he spends a lot of his time down there. The 36th District Court issued their own moratorium that lasted till August 16th. But in my opinion, they're not even out of this moratorium yet. Before COVID, each judge could handle up to 50 cases per session. So 50 in the morning and 50 in the afternoon, although most of them usually had some overflow for the afternoon, never really a full docket. Unfortunately, now they've come out of their moratorium, they're reducing it down to 16 cases per judge per day was the last I've heard. Brian could correct me if that's changed. But what that means is they're going to just be getting farther and farther behind. Right now, they are only hearing cases that are dealing with writs or orders of eviction that expired prior to or during the COVID process, which means their judgments from January, February, March. They're finally getting to second hearings on those cases. They have not heard or even filed, as far as I know, any new non-payment cases. They're sitting down in the mailroom, and it's going to be a while. Even on the writ evictions, those hearings, if the resident does not show up, they're going to be adjourned for several weeks, if not up to 2 months, depending on how much legal aid is asking. Other thing that the Supreme Court executive order did is it created a different way of handling the eviction process or the landlord case from start to finish. Before, as Brian mentioned, you'd have one hearing date. Most of the cases were resolved on that date. Coming out of this COVID problem, the courts are now saying you have to have at least 2 hearings in almost all cases. The first hearing being a pretrial that simply tells the resident they've got the right to go get an attorney and they've got the right to go get government help for their rent. In my opinion, this could have been done much more effectively. Quite frankly, the notice we give them tells them they can get an attorney. The summons they receive tells them they can get an attorney. And that's served on them both via mail and in person or posted on the door. So they've been notified 3 times already. The Supreme Court decided they need to have a 4th time. So that is creating a second hearing on virtually all cases. Only time that's not the case is if you had personal service where the process server handed the person the paperwork at their door and the resident does not show up to court when an in-person court appearance was permitted. Most cases, the court appearances are done by Zoom. In most of the larger cities, there's a few outlying areas, especially if you go to the west side or the northern part of Michigan, where the COVID has not been that much of a problem. The courts came out of their Zoom requirements much faster. But basically, every case is going to require 2 hearings. And as Brian and Matt can attest, that is creating a bottleneck and a nightmare for our calendar. I just counted up in the last 2 weeks, I've had over 140 court hearings. Luckily, they're all by Zoom so that I'm able to bounce back and forth. I've actually had at one point where I've been in 3 different courts using 3 different devices, a laptop, tablet, and a desktop, all at one time, turning, and turning to talk to the different judges. And it's actually worked out okay. But that's a brief history of what we're currently experiencing. If your property is located in, as an example, up in Mayo, Michigan, you're going to have no problem whatsoever. They've already come out of the executive order. They're back to normal operations. And a lot of the smaller courts are back to normal operations without a problem. The larger courts, which I would say would be Kalamazoo, Saginaw, Detroit, and most of the courts in the Detroit metro area, they're going to be backed up for a while. Detroit 36th District Court, I have absolutely no clue. My guesstimate, and Matt could probably speak to the future here, but my guesstimate is that court will not be back to normal for at least 12 months. And Brian, who's down there all the time, will probably be able to speak more to that. And I think I'm going to wrap up my session right here. As attorneys, we're trained to talk and talk and talk. So I'm going to cut that short and turn this over to, I guess, my Wolverine counterpart here, Mr. Miller.
That's right. Call me the right thing, Steve. That's what you should call me. Anyway, I'm going to talk about one thing that is still going on that Steve didn't mention, because I think it's important before I talk about the future, and that is the eviction diversion program. The Michigan legislature passed a $50 million aid package to help people pay their rent. There were a number of strings attached to it. I'm not going to go too deeply into it at the moment because I'm guessing that most people are familiar with it by now, but it includes waiver of late fees, includes a discount that the landlord has to take, it includes entering a conditional dismissal rather than a judgment, and it's supposed to spend this money by the end of the year. What we've learned so far is a couple of things. Number one is one thing we've been shouting from the rooftops since March, and I've had conversations with members of the governor's office and the Supreme Court's office, that there isn't going to be the backlog of cases to be filed that they thought there was going to be. They thought there were going to be 75,000 landlord-tenant cases filed when the eviction moratorium was lifted, and there were about 15,000, which is approximately what's normal. What Steve was mentioning is true, though. Everything is taking way longer than it used to and than it should, and that's slowing down the process. I can't comment about Detroit because I fortunately haven't been there since we've restarted, but they've, it sounds like, have pretty much gone rogue, and something might have to be done with them legally. But the administrative order that Steve was referring to with other courts, some courts having made it through their backlog, suffice to say they didn't have a backlog. Once that backlog is cleared, going forward, they're supposed to go back to normal. Some of the courts have done this. Some of the courts are still doing it the way that they thought they were supposed to do it, because I think the state court administrator's office is suggesting to them that they need to spend this $50 million before the end of the year, and reports are that about $10 million has been spent so far, because for a number of reasons. One, they're not getting the money out quickly enough, and two, they didn't have nearly the backlog that they anticipated. So there's a great incentive to keep the process going to the end of the year in order to try to get this money spent. How that works out in the various courts across the state is going to remain to be seen. But going forward, there's a few things. Number one, Congress has been talking about an extension of the CARES Act, or a new version of the CARES Act, since the CARES Act expired in July. They've got a program called the HEROES Act. There are a bunch of different bills that are pending in Congress. Many of them have passed the House of Representatives. The Senate has refused to take them up. The White House is going back and forth. Should there be a $300 additional unemployment benefit? Today I heard they're willing to go up to $400. So it remains to be seen what will happen in that. The question becomes, is there going to be an extension of this eviction moratorium as legislation like the CARES Act put into place? There's been talk on both sides of the aisle, including from the president, that he's in favor of a continued eviction moratorium. So we at the PMAM have been asking people to send letters and emails to their members of Congress to say, hey, wait a minute, we don't need another eviction moratorium. It's bad policy. It doesn't provide anything that you're trying to have it provide for, and it doesn't get the landlord paid, which is a big problem with the CDC moratorium, because it just says, if you file this document under penalty of perjury, your rent still comes due, but it doesn't come due until January, which means that most people who haven't paid since March and will have not paid through December will simply come January owe 10 or 11 months of rent, which is a problem, a big problem, because there's no payment program through the CDC moratorium. Now, almost immediately after the CDC moratorium went into place on September 4th, right after Labor Day on September 8th, a anti-administrative regulatory law firm out of Washington, D.C. filed a federal lawsuit in Atlanta asking for the CDC order to be stricken down. Supposedly, there's going to be an argument in October to an injunction to strike down this moratorium. I don't know what's taken this long. I don't know when it may take place. I don't know how long it may take for a federal judge to make a decision on the validity of this CDC order. Personally, I think the order is unconstitutional for 10 different reasons and should be stricken down. But until and unless that happens, it's crazy what's happening, because some courts are dismissing cases where tenants are filing CDC declarations. Other cases are staying them indefinitely. Others are closing them like as though it were a bankruptcy. So it's a whole different world out there. But so those are the really unknowns. What's going to happen in Congress, if anything? What's going to happen with the CDC order, if anything? And what's going to happen with this administrative order from the state of Michigan Supreme Court as to whether, when the courts really finish their backlog, are they actually going to go back to quote unquote normal? I keep asking judges, are you done with your backlog? How you doing? Oh yeah, we're almost there. Yeah. The judges really don't like this procedure because it takes up a lot of their time. And, like my colleagues were talking about, the efficiencies that used to be there are now gone. The only benefit, and, maybe it's a benefit, maybe it's not, is I don't have to drive all over the state. I can do all this stuff like Steve said on Zoom, but everything takes so long. I was virtually in Kalamazoo yesterday for one case, took an hour and a half. I mean, that's granted, it didn't take me 2 hours to drive there and 2 hours to drive back, but it's a little frustrating to sit on Zoom for an hour and a half and literally do nothing. So we'll see how that goes. Joe made mention to a Michigan Court of Appeals decision that came down on September 17th on a case that I handled on appeal that I just want to mention briefly that you should be aware of. The case is called Riverbrook versus Fabodi. It's a published Michigan Court of Appeals decision, meaning it has statewide precedential value, and it has to do with emotional support animals. Emotional support animals have been a real thorn in the side of landlords for the last couple of years, and it's been just getting worse through the invalid and often fraudulent online services that are providing letters to residents so that they don't have to pay pet fees, or they can have animals that they're not otherwise allowed to have. And so what the Court of Appeals basically held, and I'll just summarize really briefly, is that the letter is not good enough. Courts have to delve into the accuracy and legitimacy of the diagnosis that's provided. They have to carefully consider the reliability of the methods employed as well as the opinion. So it made clear that ESA letters should not just be simply taken at face value. They have to be considered and they have to be scrutinized. And one final thing I'm going to mention, because this literally just happened today. If you're looking for something fun to do, go to the Michigan Legislature website and type in Senate Bill 846. This was a bill that we literally found out about on Tuesday because it was identified as the Hotel and Lodging Pricing Protection Act. But that's not really what it is. In fact, what the purpose of the bill was supposed to be was to prevent people from gouging in a state of emergency when, for example, the sponsor talked about how a hotel in his district that normally was $59 a night, during an emergency, the price was increased to $400 a night, and how that should be inappropriate. And while I agree that that would be price gouging, what this bill actually does is this bill institutes an automatic eviction moratorium anytime there is a state of emergency, federal, local, or state, automatically, without any prospect of payment for the landlord. It just simply provides an automatic eviction moratorium that runs through the entire state of emergency and 30 days thereafter. It also talks about rent control, which was invalidated in Michigan in 1988 and is not allowed to even be mentioned by a municipality. This bill talks about rent control as though it exists. So I had the privilege today of testifying in front of the Senate committee handling this bill, and it was very disconcerting to me that a bill that was presented as a hotel lodging price gouging bill actually institutes a statewide eviction moratorium anytime there's a state of emergency. So hopefully we got the message across, and this bill isn't going to go anywhere. But the moral of the story is you have to be vigilant about what's going on in Lansing, in your municipalities, and in the federal government. So please, if we've learned anything during this crisis, laws have been changing, on a dime. These executive orders were coming out both from the Supreme Court and from the state of Michigan. You just have to make sure you're aware of what's going on, because things can change awfully quickly. And I can't imagine what it would be like if we had a statewide eviction moratorium that had been in place since March with this, if this bill were law, and there'd be no prospect for tenants to have to pay. So with that, I will stop, and I thank you for your attention.
Thank you, guys. I think a couple things that I noted that I just wanted to mention is, while we're talking about eviction here, we want to try and save as many residents as we possibly can. So one of the things we've done at KMG is we've really changed all of our letters to direct everyone to the EDP program, the eviction diversion funds, and in really going above and beyond to try and drive someone to those resources. I think the challenge that I think about is those households that are causing the problems at our communities, those that are the health and hazard related households, and not being able to remove them from the property to protect the rest of the community and our residents. I think that's one of the biggest concerns for me as well. So I'd like to open it up to questions. David, if you've got any comments, I know as we move forward, if the eviction moratoriums continue, obviously we've got a lot of people that all of us answer to with syndicators and agencies, and it was hard to stay on top of delinquency at times in the past, and now it makes it even more difficult because it's less in our control like we used to. We used to have really good elections policy that could drive you into that eviction process if necessary. So it's a little bit more difficult now. But so let's open it up to questions. I think, Steve, did I see you raise your hand? Steve Gann, did you have?
Oh, no, I did not.
Joe, I'll jump in and just make a comment to piggyback on what you were just talking about. And I think that for those of you that are in the property on the operations side out there, as Joe mentioned, we put a letter out. Frequently, we send out communications to our residents, and with the exception, frankly, of a few people out there that I think are just trying to use the system, if you will, we have found that people are pretty cooperative, and they appreciate the fact that we're trying to help them along the way. We're trying to find resources so that they can pay rent. They really do not want to be behind on their rent. They are very, very afraid that they are going to get evicted. And so I think you got to approach this with some real compassion with these folks. And I think you'll find you'll get a significant amount of cooperation and appreciation from your residents for trying to help them out here. And we're not necessarily taking this approach of, pay or you're out. It's, hey, we want to work with you, as long as you're willing to give it a try and we can get through this thing together. We want you to stay and we want you to keep you in place. And I just think that there's a significant amount of appreciation from our residents when you take that approach to it. So.
Yeah. It looks like Krista has a question.
I do. I'm wondering I want to know if I'm mistaken in the EDP program. I thought that it was they would help up to 3 months and then maybe possibly an extra 30 days, and there's a cap of 3,500 or something like that. Has that changed?
Well, initially when it came out, Krista, it was the cap is $3,500, and that's based on your income percentage of AMI, and they will pay up to 2 months of future rent as well, in addition to that $3,500. But that would be capped at $1,200. I think initially they were saying they would pay up to 1 month future rent. They changed that, extended that just a little bit. It's now up to 2 months, but it's capped at $1,200. So if your rent's $700 a month, they'll pay that first next month, and then the portion of the following month, but it'll cap at 12.
Okay, and I have not a lot, excuse me. Obviously, my 2 largest counties in my portfolio, we have had no response from EDP, from the Harris whatsoever. So I'm concerned about the residents that are still not paying rent, thinking that this is going to be covered all the way back to April.
So you must be talking Wayne County, and which other county?
Actually, I am in Macomb. I have Macomb and Oakland, and neither one of them have responded.
I've not had any problem with Oakland. A couple of have gone through okay. So I can't speak to that one. Brian, Matt, have you had problems with either one of those?
Oakland actually has their own pot of money that they've been using as well. So I haven't heard about a problem in Oakland, but I have heard about all kinds of problems all across the state about the Harrahs really being slow. And it becomes a question for the landlord to decide whether they're willing to wait. I mean, generally, if you've signed a conditional dismissal, it has a time limit on it. And a lot of people are being very forgiving about that time limit. Instead of being 10 days, you know, we have clients who are waiting 3 and 4 weeks, but at some point people are just going to get fed up and they're going to say, I want my judgment, I want my writ. If you want to be patient, you can be patient. If you don't, then you don't have to. The other thing is there are people who enter into eviction diversion settlement agreements before court, and that provides that if you enter into that agreement, you're not going to file a court action. But again, if they breach that agreement, and by they, I mean the Harrah, by not paying, I would say you probably should file your case, because otherwise, you know, it may be another month before you get somewhere, and there's got to be some movement at some point, in my personal opinion.
Yeah, it's moving slow. I mean, I've not yet heard of a situation where somebody has applied and just never got paid. I mean, there are some that are still waiting, and might wait beyond the date that was promised by the Harrah. But you know, like Matt said, it's a question of patience, how long you're willing to wait. You know, as I indicated at the beginning of my presentation, I'm a little bit more jaded probably than the two of them, because, you know, if you're talking about a Detroit property in particular, the alternative is that we can take the case into court and we're not going to get anywhere with a judgment or anything like that. And so it depends on the jurisdiction. And I know you're not in Detroit, but you know, that's got to weigh into the decision of whether or not and how much you want to be patient.
Thank you.
Looks like Stacy has a question. Her hand's up.
I was curious, we don't have to, we're not going to expect the rent. I mean, we expect it, but we're not, if we don't get the rent, if we're dealing with an individual with a voucher, do they still have the legal obligation with the provider of the voucher, like about Valley Creek Housing? I mean, part of their relationship with that organization is they're making a promise to keep a commitment to make their payments. So where we weren't able to evict them, they still weren't keeping their end of things with Battle Creek Housing. I personally didn't rush to tell housing who was or wasn't paying, because then I have to be perfectly honest, then they might lose their housing and they weren't going to pay me the other share either. But what does that do for that part of it? I mean, are they roped into this somehow, or they can't, there's no punitive from their end either?
I'll speak to that.
To be honest with you, Stacy, go ahead.
Oh, go ahead, Brian.
I was just going to say that I'm not sure that there was that much forethought in the legislation or the orders that was drafted about that end of the relationship. I have not seen anything that speaks to that, those contractual obligations between a tenant and the provider of the subsidy. Presumably, they could lose their subsidy for not fulfilling their contractual obligations. How likely is that to happen? I don't think very. But yeah, I really haven't seen it addressed in anything that's come down in the way of legislation or executive orders or anything like that. I don't know if either of you have. But.
I would agree that most likely they will not penalize a resident on a payment-related matter during COVID, especially when there's the HARA and the EDP program out there that will kick in. And actually, I believe the Battle Creek HARA program does move pretty fast, and they've got a pretty reasonable legal aid over there. As one thing I didn't address, and as Matt and Brian would agree, different legal aid offices can either make things go smooth or they can create headaches for us. And so it all depends on what legal aid you're dealing with. Battle Creek, where Stacy's at, that legal aid office is pretty good. Always willing to reach out to the attorney and see what needs to be done to get it resolved without having fights in court. So that will be just fine. I know, going back to the HARA and the delays in HARA, in the Detroit area in particular, that HARA program, the administrator got changed at the very last second and put them about a month behind in getting prepared for it. So Brian may be able to speak to that, but I believe that may be part of the reason why Detroit is so backlogged, because they were a month behind according to everybody else. But as far as your specific question of will there be a penalty to the resident, I don't think so. And quite frankly, I can't imagine any judge that's going to enforce a penalty like that if the resident's able to get some type of HARA or EDP funding.
Brian or Matt, anything you guys wanted to add to that?
No, not for me, Joe. Thanks.
Anybody else have any other questions or questions for the panelists that we have today?
Joe, I got one from Laura. Her sound wasn't working. So her question is, what is the possibility of getting a non-payment case heard this year in the 36th district?
I guess since I'm the Detroit guy, I'll take that one. Yeah. Not very good, to be honest with you. I mean, I just appeared earlier this week on a case where we had a consent judgment in February or March. Resident owes $15,000, and my case was put over another 3 weeks. And when I complained very loudly and very forcefully to the judge, I was told that I should tell my client in for a nickel, in for a dollar. And so there's a very sort of blithe attitude about our inability to get any relief from the courts from a couple of the judges, not all of them, but a couple of the judges. We've been sending cases to the court in batches since the end of July, when the CARES Act moratorium lifted. We have not gotten a single one of those cases scheduled yet. We are now at the beginning of October. So the likelihood that they actually schedule it and don't just continuously adjourn it time after time, to me, is very, 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 very small.
I will agree with Brian on that one, although I also agree that in the idea of continuing to file the cases, because they have a very big mailroom there, and if you wait to file your cases until the court starts showing signs of life again, you're going to be behind another 1,000, 2,000 cases that are waiting to be heard. So although we're not getting heard, we're getting ourselves queued up, hopefully in the order that the mailroom received them. Now, whether they file in that order or not, Brian, what's your prediction?
I think they're going to be too overwhelmed to be able to follow it. I mean, I think there are a bunch of well-intentioned people who work at the courts, particularly in the administrative offices, who are going to try and follow the order, but they simply have too much volume in order to be able to effectively comply with this priority schedule and all the rest of it, I just don't see a way that they're going to be able to do it.
And the fact that they haven't begun to try just means that they're going to be farther and farther behind. It's very frustrating with some of the courts who just thrown up their hands and just like, we don't know what to do. So our response is we will do nothing. And that's not a response. And so, I mean, you know, it's not really, blame isn't going to really accomplish anything, but the Supreme Court deserves a lot of it for entering this order based really on false pretenses that there was going to be this terrible backlog. With all due respect to the court and the state court administrator's office, I mean, I really believe that this was a scenario where they wanted to institute a policy and a process that slowed down the landlord-tenant process, that made it more difficult to pursue these cases because they had the opportunity to do it. And I think they took the opportunity when they saw it. And I think it was very political. And it's frustrating for somebody who's been working, as Joe said, you know, in politics as the legislative committee chair of the PMAM since, you know, for 13 years. You know, it's just frustrating to me when the courts become political. I understand it when the legislature is political, but when the courts are political, it's a real problem. And I think that's what we have going on right now.
Right. I think one thing that we've done and we continue to try to do, knowing there are those areas that we can't get into court, you know, I would highly recommend, you know, one-on-one conversations, either phone calls or an in-person, obviously exercising social distancing with masks, but specifically meeting with those residents that are behind and trying to get them into an agreement of some kind of payment. So you can at least get some dollars coming in the door when we know that we're not going to be able to get into court for any length of time in those areas. And we've gone as far as telling a resident, hey, come into the office, we'll help you fill out the application that you need on, for the eviction diversion funds. If you need access to a computer, come on in. That way, if you've got questions, we can help. Because, you know, as we continue, obviously bad debt for the properties are going to continue to grow. You know, you heard Steve mention that multiple hearings. So the overall legal costs are going to go up for the properties as well. And anytime we can, just stay in front of that resident to be able to help them get the dollars that are out there and available to them, it's a win for both the resident and the property.
You know, at the beginning of this, I was giving the anticipation that Don would have at least one question for us. And I haven't heard from him yet.
All right. Can you hear me now? So, I've been talking to a lot of partners about evictions and, why the courts won't let us and whatnot. But I guess my question is, what's our plan? Say the courts start filling and, you start having all these orders go through. So now what? You have 10% vacancy overnight. What's the plan to refill the units? Obviously we've seen leasing has taken a drastic turn, so it's a lot of virtual tours. I think we're thinking about what to do with the current tenants, and I think we need to, as you talked about looking forward, what's the plan after all these eviction notices take effect?
Well, if I can jump in, we have a lot of clients who are not in the subsidized housing arena. We have some who are, but we have a lot of conventional properties, and a lot of our conventional clients are going forward and they are leasing very well right now. Obviously it doesn't speak to everyone in every marketplace, but nobody's complained to me in the nicer end conventional properties. Now, maybe in the lower end conventional properties, people are complaining, but it's really beyond probably the lawyer's expertise in this to talk about the business prospects of what may happen if there's a lot of moving around. But what one judge said to me when this process first restarted is that his belief would be that a bunch of residents from this property would end up moving into this property, and a bunch of residents from this property are going to end up moving into that property because they're going to get evicted because they can't pay or because they skip or do one thing or the other, and there's going to be a lot of moving around. But we'll see. I guess we'll just have to wait and see what happens.
My thought before we let the operation people talk about it is a lot of these folks, they're not going to the higher EDP program until they get into court and the court leads them down that road. So although we're going to be filing a lot of eviction paperwork, the actual number of evictions, I do not anticipate is going to be that much greater than any normal time, because it's just taking the court process to lead the residents to the trough to drink the water.
I want to mention that we do have a virtual leasing session planned. So that's another one of the options that's available. So stay tuned for that. And I can comment and say, you know, as an asset manager with, I don't know, 80 or 90 deals in my portfolio, you know, the virtual leasing situation is kind of, you know, a broad spectrum. Some people are having really, really good luck with it, and other people are struggling. I've got one property that can't lease. It's a senior property that can't lease a unit to save their lives. So, you know, and then we've got other people who haven't missed a beat and everything in between. So anybody on the ground, you know, boots on the ground, actually have any comments that I don't know? I guess we've got some regional property managers here who might be able to speak to that better.
I guess I can jump in here with some of within my 11 properties. We have only had 3 residents that were non-payment that went through the eviction diversion program. So actually, and so, you know, we have gotten our money on those, and we wrote off 10%, but we saved those residents. Some of my senior properties, we saw some vacancy as people realized through this COVID time that they needed to live with family or assisted living. But we're not having problems with leasing, having traffic in the door, and we are using virtual as well as, you know, our social distancing on site. So we really haven't experienced much of a vacancy problem because of COVID and the non-payment of rent.
Yeah, I think it's, you know, from a legal perspective, you know, it ties into probably what you guys are saying on the operational side. I think the anticipated effect of COVID on the affordable housing industry was not at all what actually happened. And so, I mean, we were anticipating, you know, the gigantic reductions in our rental incomes, and it just didn't happen. The court has obviously forecast gigantic increases in case filings. It's not happening. And so, you know, I think particularly in affordable, again, where, you know, a resident, of course, on Section 8 can expect to have their rent reduced if their income goes down. You know, senior properties where folks are on a fixed income, you know, those folks are by and large unaffected economically by COVID. And so the numbers just didn't bear out as to, you know, in terms of what was predicted. And so I think, again, the affordable housing industry in particular did a little bit better than expected, although, you know, we took somewhat of a hit. But I think it was all frankly overblown, and on a lot of the anticipated, you know, things that are in place to sort of help folks out are great, but they're probably not needed as much as what was expected.
You know, we were talking a little bit about virtual tours, and Mary said there's going to be another presentation on the leasing and the virtual tours. So for those of you in operations, I mean, if you are struggling a little bit out there, you know, one of the things that you can do to help yourself immensely is, if you haven't done it in the past, and a lot of the affordable communities haven't, really a decent website. It doesn't have to be really fancy, but something clean, something that's fighting, and something that gives the people the information they need, because more and more of those folks are heading that direction. And, you know, that's probably one of the things you can do for yourself if you haven't already done it on your properties that could help you immensely. And then as far as your tours go, if you can't do them virtually, you certainly can design them so that you can be as safe as possible, social distance, allow the prospect to go into the apartment home by themselves, that kind of thing. So, and there is a wealth of information on the internet with regard to that. And I think if you're involved with any of the like apartments.com and some of those folks, they have quite a few webinars that are either free or low cost that cover these kinds of things as well. So you may want to watch for that. So.
Mary or any of the other asset managers from Cinnaire, anything that you guys would like to add in? Maureen, how about from MSHDA's perspective?
No, I don't have anything to add, but it all sounded really, the recordings are going good. So I'm happy that it's all working out.
Does anybody have any further questions or before I turn it over to David?
So if there's not any questions, I think, Mary, are we ready to wrap it up? Okay, so first of all, I want to apologize for my disappearing act a little while ago. You know, there's always, with technology, you run that risk. So maybe you didn't notice, but, you know, I did. My computer just shut down on me for no apparent reason. But I do apologize for that. But having said that, Joe and myself and KMG, we'd like to thank all of you for joining in this, this virtual evictions presentation today. I think we got a wealth of information. We had some really good questions and some good answers out there and some comments. So again, thank all of you for that. I do want to thank Brian and, if I have to, Steve and Matt. So no, I do appreciate you guys spending your time with us today. I know that you're very, very busy. And so we do greatly appreciate you walking us through what I'm going to say is well, I don't even want to say it's the good, the bad, and the ugly. Maybe it's just the bad and the ugly. Not sure that there is any good yet, but no, we do appreciate you walking us through that. So, and then additionally, of course, we want to thank Mary and Cinnaire and MSHDA for pulling this event together. You know, I think it's something that a lot of us look forward to every year. We get to go into Lansing there, and of course we miss that networking piece. We get to see people we haven't seen in a long time, and so by the way, it's great to see all of you and your smiling faces on this Zoom call today. But we do appreciate the fact that you guys were able to pull it together and put these recordings together and make them available for everybody. So so I just like to say we hope you enjoyed it. I enjoyed the time we spent here with you guys. So, and you know, I guess best of luck out there in these trying times and these frustrating times, and hopefully the future gets a little bit brighter for us in terms of being able to get these cases, you know, through the court system, and hopefully we can save the residents and keep them in place, and we can get the rent caught up. So that's really all I had. So if there weren't any further questions, I think we're all set here. Thank you all.
Thank you, everybody.
Thanks, Joe and Dave and all of our panelists too. We appreciate your leadership on the session.
Welcome.
Thank you.
Thank you.
Thank you. Stay safe, everybody.